Hello everybody, Andy here, and I get lots of questions regarding Executive Order 13303, and the latest I have been told is that it has been rescinded. I have not found anything that officially states that there is no longer an executive order. In fact, it was signed again in 2023 on May 16th. It was extended for another year. So as far as I know, we're still under it. Somebody wants to send me proof, not from a guru or anybody else, but official proof that it has been rescinded, then feel free to send it to me. But the questions I get are, what exactly is it? Well, let's do like lots of people do and run to Wikipedia to see what they say it's about, and then we'll actually go to the actual executive order. So Executive Order 13303 was issued on May 22nd, 2003 by United States President George W. Bush to protect the Development Fund for Iraq for the rebuilding of Iraq from any legal attachments or liens. Further, it protects Iraqi oil products and interests and ownership by U.S. persons from attachment as well. What that is saying is that you can't sue Shell or Mobil or whoever may be over there drilling and there's some mistake happens. They are protected. The companies are protected. But let's go on. Executive Order 13303 also terminates sanctions specified in Executive Order 12722, 12724, and 13290 as it applies to the Development Fund. In effect, 13303 provides an extraordinarily broad legal shield for any and all contractors and mercenaries working in Iraq on behalf of U.S. corporations and any oil-related enterprise. The executive order. Wow, I can't talk tonight. The executive order also declares a national emergency to deal with the threat to a peaceful reconstruction of Iraq, which U.S. presidents have renewed every year since, most recently in May 2023, and there is a footnote there. The order's full title is Executive Order Protecting the Development Fund for Iraq and Certain Other Property in which Iraq has an Interest. Effects of Executive Order 13303. The primary effect of 13303 is the legal protection of U.S. oil companies. It is part of a broader endeavor by the Bush administration to exert control over Iraqi oil revenues. The plan centers on the Development Fund for Iraq, created by the United Nations and nominally controlled by the United States, with advice from the World Bank and the International Monetary Fund. The second part of the plan is 13303, providing absolute legal protection for U.S. interests in Iraqi oil. Controversy. Critics of this executive order contend new debt for Iraq will accrue from the new development fund for Iraq. They say that it will allow opportunities for grave abuses because it offers little illuminating context, and its tone suggests the language should be read quite broadly. These concerns stem from the apparent likelihood the fund will be used to leverage U.S. government and corporate interests. You think? The United Nations Security Council approved Resolution 1483 on May 22, 2003, ending economic sanctions against Iraq, while clearing a path for the transfer of over $1 billion US from the Oil for Food program as seed money for establishment of the Development Fund. Critics are also alarmed because all proceeds from the sale of Iraqi oil and natural gas are to be placed into the fund noting developing countries have amassed huge debts in exchange for selling out their natural resources to powerful corporations. This paradigm, they contend, cloaks corporate welfare and neocolonialism in terms of poverty alleviation, and now in Iraq as humanitarian assistance. There are differences between the original text and the executive order, which may lead a court to hold implementation is overbroad. And that's what we're going to see a great opinion here in just a second. But what is Executive Order 13303? And this is from the government website. And as I said, the title of it, it's Executive Order 13303, Protecting the Development Fund for Iraq and certain other property in which Iraq has an interest. By the authority vested in me as President, by the Constitution and the laws of the United States of America, including the International Emergency Economic Powers Act as amended, the National Emergencies Act, Section 5 of the United Nations Participation Act as amended, and Section 301 of Title III United States Code. I, George W. Bush, President of the United States of America, find that the threat of attachment or other judicial process against the Development Fund for Iraq, Iraqi petroleum and petroleum products and interest therein, and proceeds, obligations, or any financial instruments of any nature whatsoever arising from or related to the sale or marketing thereof, and interest therein, obstructs the orderly reconstruction of Iraq, the restoration and maintenance of peace and security in the country, and the development of political, administrative, and economic institutions in Iraq. This situation constitutes an unusual and extraordinary threat. Folks, I've been up for quite a while now, and I'm sorry, but I just had time. I've been planning to get this done for some time, and I've got a little bit of time before I head to bed, so I thought I'll get it done, get it posted, and move on. But anyway, I apologize. Let me back up to the last sentence again. Oh, this has all been one long, drawn-out sentence. And economic institutions in Iraq. This situation constitutes an unusual and extraordinary threat to the national security and foreign policy of the United States, and I hereby declare a national emergency to deal with that threat. I hereby order, unless licensed or otherwise authorized pursuant to this order, any attachment, judgment, decree, lien, execution, garnishment, or other judicial process is prohibited and shall be deemed null and void with respect to the following: the Development Fund for Iraq and all Iraqi petroleum and petroleum products and interest therein, and proceeds, obligations, or any financial instruments of any nature whatsoever arising from or related to the sale or marketing thereof, or interest therein, in which any foreign country or a national thereof has any interest, that are in the United States, that hereafter come within the United States, or that are hereafter come within the possession or control of United States persons. Section 2. As of the effective date of this order, Executive Order 12722 of August 2nd, 1990, Executive Order 12724 of August 9th, 1990, and Executive Order 13290 of March 20, 2003 shall not apply to the property and interests in property described in Section 1 of this order. Nothing in this order is intended to affect the continued effectiveness of any rules, regulations, orders, licenses, or other forms of administrative action issued, taken, or continued in effect heretofore or hereafter under Executive Orders 12.722, 12.724, or 13.290, or under the authority of IEEPA or the UNPA, except as hereafter terminated, modified, or suspended by the issuing federal agency, and except as provided in Section 2 of this order. For the purposes of this order, the term person means an individual or entity. The term entity means a partnership, association, trust, joint venture, corporation, group, subgroup, or other organizations. The term United States person means any United States citizen, permanent resident alien, entity organized under the laws of the United States or any jurisdiction within the United States, including foreign branches, or any person in the United States. The term Iraqi petroleum and petroleum products means any petroleum, petroleum products, or natural gas originating in Iraq, including any Iraqi origin oil inventories wherever located, and the term Development Fund for Iraq means the fund established on or about May 22, 2003 on the books of the Central Bank of Iraq by the administrator of the Coalition Provisional Authority responsible for the temporary governance of Iraq and all accounts held for the fund or for the Central Bank of Iraq in the name of the fund. The Secretary of the Treasury, in consultation with the Secretary of State and the Secretary of Defense, is hereby authorized to take such actions, including the promulgation of rules and regulations, and to employ all powers granted to the President by IEEPA and the UNPA as may be necessary to carry out the purposes of this order. The Secretary of the Treasury may redelegate any of these functions to other officers and agencies of the United States government. All agencies of the United States government are hereby directed to take all appropriate measures within their statutory authority to carry out the provisions of this order. Nothing contained in this order shall relieve a person from any requirement to obtain a license or other authorization in compliance with applicable laws and regulations. This order is not intended to and does not create any right, benefit, or privilege, substantive or procedural, enforceable at law or in equity by a party against the United States, its departments, agencies, entities, officers, employees, or agents, or any other person. This order shall be transmitted to the Congress and published in the Federal Register. George Bush, the White House, May 22, 2003. Message to the Congress reporting the declaration of a national emergency with respect to the Development Fund for Iraq. I'm not going to go into all of that, but as far as something going on, looky here, on May 17th, 2023, Biden extends national emergency declaration for stabilization of Iraq. What a con they have going. It's all about power. It's all about control. Oh, there's more to it than just that, but that's the primary reason. But Joe Biden on Tuesday extended a national emergency declaration on the stabilization of Iraq issued by the White House 20 years ago, saying the obstacles to the reconstruction of the war-torn country still possess a threat to Washington's foreign policy and national security. So, there you go. He signed it again. Expires May 16th, 2003. But another notice, May 16, 2023, notice on the continuation of the national emergency with respect to the stabilization of Iraq. On May 22nd, 2003, by executive order, blah, 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 blah. This notice, the obstacles to the orderly reconstruction of Iraq, the restoration and maintenance of peace and security in the country and the development of political, administrative, and economic institutions in Iraq continue to pose an unusual and extraordinary threat to the national security and foreign policy of the United States. For this reason, which has not been proven whatsoever, they just say this is it, so it has to be it. And they do what they do to maintain control. But is it even legal? I don't think Iraq has fully challenged it. I don't know what court would take this up, but I think they could easily prove that the United States is abusing its power. But let's take a look. This is written by Claire Kelly. The War on Jurisdiction, Troubling Questions about EO 13303. This was interesting. Maybe boring to hear me read it, but let's see what she has to say. Despite all the attention given to the war in Iraq, little notice has been given to an extraordinary executive order issued in connection with the Iraqi conflict, which arguably challenges our notions of separation of powers, due process, and access to the courts. That order, issued on May 22, 2003, is Executive Order 13303, protecting the development fund for Iraq and certain other property in which Iraq has an interest. The order's simple and straightforward facade masks troubling questions, in particular whether the President attempted to modify or withdraw federal jurisdiction and whether the Supreme Court should allow him to do so under the current analytical framework. And we're not going to get into the footnotes here, we may, but right now, no. The order purports to protect the development of political, administrative, and economic institutions in Iraq, yet the order appears to extend perpetual judicial immunity to oil companies doing business in Iraq by precluding a class of claims against private companies without providing an alternative forum for those claims. This essay examines the terms of the order and how a court may interpret them, the analytical framework under which a court would evaluate the order, and the troubling questions that the order raises. To illustrate how the order might work, consider Company X, a company organized under the laws of Delaware formed for the purpose of drilling for oil in Iraq. Company X fortunately secured the right to extract Iraqi oil and sell it on the world market. Assume further that Company X will remit a certain percentage of the proceeds from its oil-related activities to the Development Fund for Iraq, while some of the oil proceeds will be remitted to Company X as profits. Finally, assume that Company X issues stocks or bonds and pays dividends to its shareholders. Suppose that while drilling for oil, a terrible accident occurs in which an American employee of Company X is hurt and oil spills causing environmental damage either in Iraq or elsewhere. Suppose that the injured American employee and the people harmed by the oil spill successfully sue Company X, establishing its liability. However, EO 13303 may prevent those parties or any other injured parties from enforcing a judgment against Company X because the order appears to extend perpetual immunity to oil companies doing business in Iraq. Arguably, it insulates those companies from liability arising from or relating to their activities in Iraq. Initially, one might think that the President, by virtue of his foreign affairs powers, both can and should protect companies dealing with Iraqi oil from costly litigation. American litigation can be abusive, and a flood of litigation against companies doing business in Iraq could affect U.S. efforts to promote the stable reconstruction of Iraq. Although this is a noble goal, allowing the President to preclude access to the courts by executive order threatens our understanding of the doctrines of judicial review and separation of powers. If the President can prevent unknown litigants from enforcing judgments against private companies in the name of foreign affairs without providing an alternative forum for their claims, then he can do almost anything in the name of foreign affairs. It is the beginning of a war on jurisdiction. This essay raises for consideration some of the troubling implications and questions concerning Executive Order 13303. In this essay, I first consider the plausible implications of the order and whether it attempts to grant wholesale immunity to oil companies doing business in Iraq. Second, I discuss how the Supreme Court should evaluate this order. Finally, I conclude that Executive Order 13303 attempts to immunize oil companies doing business in Iraq and withdraw or modify federal jurisdictions. Although potential plaintiffs may seek to establish liability against an oil company, they are perpetually precluded from enforcing any successful judgment without first obtaining permission in the form of a license from the government. Therefore, the Supreme Court should invalidate this executive order because the President lacks inherent power to issue the order and lacks explicit or implicit authorization from Congress. Whether the Department of the Treasury, whether the Department of the Treasury eventually grants a license is irrelevant. The attempt to immunize private companies from potential lawsuits without congressional permission and without establishing an alternative forum is without authority or precedent. And I would say right there that if the Supreme Court, I cannot see them allowing it because I don't think the Constitution allows one to be privileged over someone else. So there would be a hard argument there. And that's why I think Iraq should challenge this executive order. But let's go on. Even if the Constitution or Congress authorized the President to issue the order goes too far because by failing to provide an alternative forum, it impermissibly withdraws and modifies federal jurisdiction, raises the possibility of an unconstitutional taking, and improperly immunizes private companies. Although an exhaustive analysis of all these issues is beyond the scope of this essay, it does provide a platform for the beginning of a much-needed discussion. And I agree 100%. Why Iraq has allowed this for 20 years is mind-numbing. And Iraq has got to forcefully take a stand against the United States. If this is supposed to help them in their reconstruction efforts, it's more of a case that we're standing in their way by not allowing them to have access to their funds. But anyway, I'll go on. Why executive order isn't a typical blocking order. At first glance, this executive order looks like a typical blocking order of foreign assets administered by the Office of Foreign Assets Control. Such orders issued by the executive in a time of crisis or emergency prohibit the transfer of property belonging to a foreign government, thus pressuring the leadership of a country to resolve a crisis or comport with the executive's desires. Boom. Control. It's all about control. For example, by blocking Libyan assets, the executive prevents the Libyan government from voluntarily transferring funds that come within the U.S. or within the control of a U.S. person, whether to protect the funds, pay for goods or services, or simply repatriate them without U.S. permission. Additionally, judicial process cannot be used to move the funds without permission. Thus, if someone obtains a judgment against the Libyan government and seeks to enforce that judgment by attaching Libya's assets in the Bank of New York, for example, that person will not be able to do so without U.S. government's permission. The U.S. government can thus control and use Libyan assets as leverage in its relations with Libya. And why they would use Libya as an example, everything that was done with Libya was a complete farce. Gaddafi being taken out, he was someone that the Clintons couldn't control. And I think most Libyan people would tell you the good he did for that country. But anyway, I'll get off my high horse here. Typical blocking orders, such as the Libyan blocking order, are reasonable tools for supporting and implementing the executive's foreign policy positions. But this executive order is different. Instead, its terms are uniquely and deeply troubling. A close examination of the order's language reveals that it does not block the transfer of property in order to secure leverage over a foreign government. Rather, it attempts to extend perpetual immunity to oil companies doing business in Iraq. It isn't a typical blocking order. The language of this executive order reveals that the order intends to discourage or even preclude lawsuits connected to Iraqi oil. And it goes on to talk about a statement from the executive order. The order then defines petroleum and petroleum products as any petroleum products, or natural gas originating in Iraq, including any Iraqi origin oil inventories wherever located. The order does not block transfers of property generally, but only the use of judicial process to transfer such property. Voluntary transfers of petroleum and petroleum proceeds are permissible. The order does not stop a company, such as our hypothetical company X, from repatriating profits or issuing stocks or debt in connection with its activities in Iraq, because these are voluntary transfers of property. The order prohibits only the transfer of petroleum or petroleum proceeds by means of judicial process, including attachment, judgment, decree, lien, execution, and garnishment. The order's goal appears to be protecting property from lawsuits, thereby immunizing private companies. The order grants immunity to oil companies operating in Iraq. The combination of the failure to block voluntary transfers and the perpetual grants of transferable protection to all proceeds from or related to the oil indicates the executive's attempt to immunize oil companies doing business in Iraq. Although none have yet been issued, the order provides that the Secretary of the Treasury is authorized to issue regulations. First, the order protects not just oil or money from oil, but money in any way related to oil. A reasonable construction arising from or related to the sale or marketing thereof and interests therein. Is that money having any connection with Iraqi oil is immune from judicial process. Thus, the protection could arguably extend beyond the mere sale of the Iraqi oil to the resale, marketing, and retail sale of this oil or products derived from it. Moreover, the order protects not only money arising from, but money related to the sale of the oil. This immunity could extend as far as an ingenious lawyer could imagine. Consider again the example of Company X, and suppose that Company X resold its Iraqi oil to a refinery and shipped the oil to the refinery. If an oil spill occurred en route to the refinery, parties harmed by the spill would not be able to enforce a judgment against Company X if all of Company X's assets could be traced to the oil. Therefore, one could interpret the language to mean that although one could sue Company X for its conduct in Iraq, one could not satisfy any judgment by moving against monies traceable to Iraqi petroleum products. Now see, what they're saying is, there's an oil spill, all these people, anybody injured, files suit against Company X. They're not saying they can't be sued, because anybody can sue anybody for anything. What they're saying is that while you may get a judgment, you can't get any money. They are protected from having to pay up, to pony up on any judgment declared on them through this executive order. Okay. Presumably, one could move against Company X's other assets, but Company X has two possibilities open to avoid having any judgment enforced against it. First, when Company X forms, it may limit its activities to the exploration, sale, and resale of Iraqi oil. If its only activities involve Iraqi oil, then it may argue that all of its monies are protected by the executive order. Second, even if it had other activities, or if a plaintiff could pursue related companies, Company X could argue that because money is fungible, any action against Company X for conduct relating to the Iraqi oil automatically relates to the Iraqi oil. If either of these strategies prove successful, the executive order would preclude any action to collect the damages of such a suit. Second, the failure to block voluntary transfers allows the immunity that first attaches to the oil to transfer as the oil changes hands. The order allows persons to transfer both the property and the protection afforded to the property. Oil that is immune from judicial process when owned by Company X remains immune if Company X chooses to sell or otherwise transfer it to Company G. Further, two clauses suggest that interests within the U.S. or in the control of the U.S. persons are immune that are in the United States and or come within control or possession of the United States persons. Finally, perhaps because persons include corporations, any interest held by Company X, such as Company X's profit, is protected by the order. Third, the immunity arguably follows property even after it is transformed. The order protects from judicial process all Iraqi petroleum and petroleum products and interests, including proceeds, obligations, or any financial instruments of any nature whatsoever. How pathetic is this? Old Bushy Boy was protecting Daddy and all his friends' oil interests. Right? Okay, this broad language appears to cover everything: crude oil, refined gasoline, profits, stocks, and debt. Thus, if Company X issues stocks in its oil exploration efforts in Iraq, the immunity that attached first to the oil and then to the money from the oil now attaches to the stock, because the stock is a proceed of the oil. If immunity flows from purchaser to purchaser, courts will be unable to reach any instrument traceable to Iraqi oil. The plaintiffs in a suit against Company X may be able to obtain a judgment that Company X wrongfully harmed them, but the executive order will thwart their efforts to satisfy their judgments. The overly broad and ambiguous phrasing of this order renders these strategies possible. The combination of arising from or related to the sale or marketing thereof and interest therein, and proceeds, obligations, or any financial instruments of any nature whatsoever seems intended to thwart all claims against companies doing business in Iraq. Money from oil is protected, and the phrase "from oil" includes any money relating to oil. The protection afforded to the money is transferable and thus seems to create perpetual protection from enforcement of all lawsuits arising from or relating to activities involving the production, sale, or marketing of Iraqi oil. One could come up with several things. What company here that buys items that are derived from Iraqi oil could say no, because this is related to, we bought the oil from Company X, so we can't be held liable because this is related to that oil. We use their oil in this product. It may have nothing to do with actual oil or anything else, but there's plastics, there's so many things made from oil. All they've got to do is have something leaking them to someone else, to someone else, to someone else, to Company X, and boom, protected, because it is related. One could argue that the order's broad language strives to achieve a noble objective, to protect money needed for Iraqi redevelopment from costly, possibly frivolous lawsuits, which again I find nonsense. It's not Iraq that would have to pay, it's the company that has a contract. If this was so important, if reconstruction were really the goal here, and not covering Buddy Boy who funds my campaign, or who I'm heavily invested in, or where I make my millions, if it was really for reconstruction protection, then there's no need for all this, right? You could word it in such a way that it would protect Iraq, not necessarily a private company. I got to figure out where I was here. If the order only contains Section 1, monies flowing into the development fund from the sale of oil would be protected, and monies that went to U.S. oil companies would not. Likely UN Resolution 1483, EL 13303, could have similarly protected the oil from suit until its first sale. Exactly. Protecting Iraqi oil up to the point where title passes to the first purchaser would effectively protect the assets intended for rebuilding Iraq. But this EO goes further, extending that immunity to private parties having any subsequent interest in the oil, and in doing so apparently immunizing private parties from future suits any way related to Iraqi oil. And this is just an overly dangerous, slippery slope that they're on, and it's time the Supreme Court get in and nullify this EO and give Iraq their freedom back. The analytical framework to evaluate the order. This order exceeds the parameters sanctioned by the Supreme Court because it goes beyond the boundaries of Daines and Moore versus Reagan, and Youngstown Sheet and Tube Company versus Sawyer, the two principal cases that establish the criteria for evaluating the order's constitutionality. These cases support the view that in certain times of crisis, the executive may settle in its nationals' claims based upon its inherent powers and the implicit consent of Congress by effectuating a change in law so that an alternative forum can resolve these claims. The executive might argue this framework should expand to include this executive order, and that the change of law paradigm adopted in that case should apply here. However, a court should reject such an argument because the president likely lacks inherent, explicit, or implicit authority to issue the order. Further, even if the president had authority, this EO lacks the criteria for extending the change of law analysis. The analytic framework, Youngstown Sheet and Tube Company versus Sawyer, involved President Truman's effort to seize steel mills in the wake of a nationwide strike. The court found that the president must act either pursuant to an act of Congress or pursuant to his inherent constitutional authority. Justice Jackson's concurring opinion in Youngstown noted that where express or implied authorization from Congress exists, the president's powers are strongest because he is exercising his own powers as well as those delegated to him by Congress. Absent congressional authorization, the president may enter a zone of twilight where he and Congress may have concurrent authority, or in which its distribution is uncertain. In a separate Youngstown concurrence, Justice Frankfurter noted that a pattern of long-standing congressional acceptance of presidential practice could be viewed as a gloss on executive power. In Dames and Moore, the court applied the Youngstown framework to suits arising out of the Iranian hostage crisis. On November 4, 1979, Iranian militants seized the American embassy in Tehran, Iran, and held 52 Americans as hostage for over a year. After the hostages taking, President Carter, pursuant to the International Emergency Economic Powers Act, declared a national emergency and blocked the removal or transfer of all Iranian property subject to U.S. jurisdiction. President Carter's EO blocking Iranian assets, the Iranian blocking order, provided the President authorized the Secretary of the Treasury to promulgate regulations to carry out the Iranian blocking order. Shortly thereafter, the OFAC issued regulations to carry out the Iranian blocking order that provided, unless licensed or authorized, any attachment, judgment, decree, lien, execution, garnishment, or other judicial process is null and void with respect to any property in which on or since November 14, 1979, there existed an interest of Iran. On November 26, 1979, President Carter granted a general license authorizing certain judicial proceedings, but not allowing the entry of any judgment or decree or order. The hostage crisis lasted a total of 444 days until the hostages' release on January 20, 1981. They were not about to test Reagan that quick into his presidency. Early in the saga, Americans expected to learn of the hostages' release when they turned on the evening news. After more than a year, the country was less sanguine. A failed rescue attempt only emphasized the country's impotence. After a frustrating year, finally, in January 1981, the Algiers Accords secured the release of the hostages. The Accords called for the creation of a claims tribunal and a termination of all legal proceedings in the U.S. courts involving claims of U.S. persons against Iran. They nullified all attachments and judgments, prohibited further litigation based on such claims, and called for the termination of claims through binding arbitration. On January 19, 1981, President Carter issued a series of executive orders implementing the accords. These orders revoked all licenses permitting the exercise of any right with respect to Iranian funds, notified all non-Iranian interests in such assets acquired subsequent to the blocking order, and required banks holding Iranian assets to transfer them to the Federal Reserve, and prohibited all claims by U.S. nationals, including the former hostages, against Iran. Despicable. In February 1981, President Ronald Reagan issued Executive Order 12294 that ratified Carter's January 19, 1981 orders and suspended all claims covered by the Algiers Accords. Executive Order 12294 provided that such claims have no legal effect in any action now pending in any court of the United States. However, the subpoena of a claim ceased and the claim was revived if the U.S. Iran Claims Tribunal determined that it did not have jurisdiction. The plaintiffs in Dames and Moore challenged the Iranian blocking order and the Iranian suspension order by claiming that the president lacked authority for the orders and that the orders violated the separation of powers doctrine by divesting the federal courts of jurisdiction. The court found that the IEPA specifically authorized the president to block the transfer of funds and noted IEPA's purpose. This court has previously recognized that the congressional purpose in authorizing blocking orders is to put control of foreign assets in the hands of the president. Such orders permit the president to maintain the foreign assets at his disposal for use in negotiating the resolution of a declared national emergency. The frozen assets serve as a bargaining chip to be used by the president when dealing with a hostile country. Because the president used the Iranian blocking order to place Iranian assets within the president's control for use as leverage, the Iranian blocking order fell squarely within the IEEPA and was therefore constitutional. The Iranian suspension order faced more serious challenges than the Iranian blocking order because the IEEPA did not directly support it. As the Supreme Court noted, the claims of American citizens against Iran are not in themselves transactions involving Iranian property or efforts to exercise any rights with respect to such property. And in personam lawsuit, although it might eventually be reduced to judgment and that judgment might be executed upon, is an effort to establish liability and fix damages and does not focus on any particular property within the jurisdiction. The terms of the IEEPA therefore do not authorize the president to suspend claims in American courts. The Supreme Court got one right here. If I am injured because they deal with another country and they have negotiating powers, especially once those hostages were released, they're gone. There is no further national emergency. Those people should have been able to file heavily and never had to worry about a financial thing in their lives after they were released. But anyway, the IEPA did not confer power to the president to suspend or transfer claims to the Iran-U.S. Claims Tribunal. In order to uphold the suspension order, the court had to find that the president either acted within his inherent powers or with the implicit consent of Congress. In Dames and Moore, the court found that the president acted both within his inherent powers and with Congress's implicit consent. The court acknowledged the president's inherent authority to enter into executive agreements such as the Algiers Accords. Yet, in reading the court's opinion, one senses that this recognition of the president's inherent power pales in comparison to its recognition of Congress's implicit approval of presidential claim settlement. The court stated, crucial to our decision today is the conclusion that Congress has implicitly approved the practice of claim settlement by executive agreement. The Iranian suspension order helped settle an ongoing crisis and the claims that arose from it by implementing this executive agreement. Alright, so we're going to apply this framework to the executive order. The first step in Dames and Moore analysis examines whether Congress has authorized the President to act. Unlike the Iranian blocking order in Dames and Moore, this executive order cannot be justified as authorized under the IEEPA, which grants the President the power to declare a national emergency and block the transfer of property in cases of extraordinary threats to national security, foreign policy, or the economy. And unlike the typical blocking order, this executive order does not block the voluntary transfer of property, but only the transfer of property through judicial process. At the same time, the order goes both too far and not far enough to seek refuge under the IEEPA because it fails to truly block property. Instead, it only blocks lawsuits against private parties. As previously discussed, the Libyan blocking order is an example of a typical blocking order. The Libyan sanctions regulations provided that no property or interest in property may be transferred, paid, exported, or withdrawn, or otherwise dealt in. It thus protects a pot of money so that no one can touch it without government permission. This EO is different. It does not operate as if to bury the money in a bank vault protected by U.S. government guards, so it can be used as leverage by the U.S. Instead, it builds a never-ending tunnel for the money to pass through from private party to private party, protected from interference by the judicial process, perpetually protecting profits from Iraqi oil without necessarily protecting the development fund for Iraq. This EO merely masquerades as a blocking order. Nothing in the order prohibits our hypothetical Company X from moving money, repatriating profits, or paying dividends out of Iraqi oil profits. Iraqi property is not blocked. Interests in Iraqi petroleum are not blocked. Profits from oil sales are not blocked. The only things blocked are attempts by potential litigants to satisfy a judgment by attaching oil proceeds and property arising from or related to oil or oil proceeds. This protection extends to U.S. persons defined by the order to include entities, i.e. corporations. Thus, the order both goes further than the IEEPA would allow by perpetually protecting private persons from suits, and at the same time fails to fulfill the purposes of the IEEPA by not isolating the property so that it can be used as leverage by the U.S. government. As with the Iranian order, Dames and Moore, this order cannot look to the IEEPA for explicit congressional authority. In order for the President's acts to be valid, he must act either pursuant to his inherent powers or pursuant to the implicit consent from Congress. The court in Dames and Moore relied primarily upon the President's acting with the implicit authority of Congress, as evidenced by long-standing congressional acquiescence in matters of claims settlement. It also noted the President's inherent authority to enter into executive agreements. This order can find no such refuge because no history of congressional acquiescence exists here, and the order does not implement any executive agreement for the settlement of claims between a sovereign and the citizens of the U.S. At least one court has been reluctant to find implicit congressional authority to suspend claims absent the criteria in Dames and Moore. In National Oil versus Libyan Sun Oil, National, an entity owned by the Libyan government, sought to enforce an arbitral award against a U.S. company that had violated in contractual obligations. The U.S. company, Sun Oil, claimed that the Libyan regulations barred the entry of judgment without an OFAC license. In response, National argued that the regulations barred only the unlicensed execution of any judgment. In other words, Sun Oil argued that the blocking order precluded the establishment of liability, while National argued that these regulations blocked only the use of judicial process to enforce an already entered judgment. The district court agreed with National and found that the order did not bar the entry of judgment. It likened barring the entry of judgment to the Iranian suspension order in Dames and Moore and found that the IEEPA did not grant the president such power, and that Congress had not granted power implicitly as it had in Dames and Moore. The court distinguished the president's power in Dames and Moore because in National Oil no executive agreement existed to settle claims. Congress had not explicitly or implicitly authorized the president to block lawsuits generally. All right, the troubling questions raised by this executive order. Has the executive withdrawn or modified federal jurisdiction? Even if the president had explicit, implicit, or inherent power to issue the order goes too far because arguably it does not merely change the law as allowed in Dames and Moore, it modifies federal court jurisdiction. The dissimilarities between the language, the origin, and the alternatives provided with the Iranian suspension order, which was upheld in Dames and Moore, and this EO, caution against an automatic adoption of the Dames and Moore change of law analysis. This is not a mere change in the law, it is the blocking of access to the courts by executive order. Whether Congress would have the power to cut off access to the courts is a separate question. One of the most troubling elements of this EO is that the executive, not Congress, is modifying federal jurisdiction. The court's language blocks the use of judicial process against not just specific property but interests, however transformed or transferred, and it does so indefinitely. The order thus insulates persons holding money traceable to Iraqi oil from lawsuits to collect damages, making it futile to pursue a remedy against oil companies operating in Iraq, since that remedy cannot be enforced. Perpetually removing the ability to enforce a judgment is tantamount to cutting off a federal jurisdiction. One might argue that the president merely suspended a remedy, not a right. But at some point, perpetually suspending a remedy destroys the right as well, because the order destroys all remedies indefinitely without providing an alternative remedy. It appears that it has gone beyond the line drawn in Dames and Moore and has withdrawn jurisdiction. Courts have refused to rely upon Dames and Moore to extend the application of the change of law paradigm to questions of jurisdiction. In another case, the 11th Circuit Court of Appeals refused to find that the Cuban asset control regulations required Cuban plaintiffs to get a license in order to cross-claim against a U.S. party in an interpleader action. Is the failure to provide an alternative forum an unconstitutional taking? The lack of an alternative forum also raises serious concerns of an unconstitutional taking. The president may only dispense with an alternative forum under very limited circumstances. Although Dames and Moore required an alternative forum, since then, at least one circuit court has retreated from that requirement. In Belk v. U.S., former hostages challenged President Carter's failure to provide a forum for their claims against their captors. The Federal Circuit considered the hostages' claims for personal injury, which the Algiers Accord suspended, for which, unlike the claims of Dames and Moore, were not cognizable before the U.S. Iran Claims Tribunal. The former hostages argued that the failure to provide an alternative forum took their claims for the public benefit and that the takings clause entitled them to compensation. The Federal Circuit disagreed, finding that the failure to provide an alternative forum alone did not constitute a taking. Where the particular party was the intended beneficiary of the action in question, the court would not find a taking just because the action also incidentally benefited the public at large. Since hostages secured the greatest advantage from the Algiers Accord, their freedom, the court refused to construe the implementation of the accords as a taking. Confused yet? The difference between the Iranian crisis and the present situation is startling when one considers the failure to provide an alternative forum. Here, there is no claim that the precluded potential litigants benefit from the order. Indeed, the potential litigants remain unknown and their claims unrealized. In contrast to the hostages in the Iranian crisis, potential litigants do not receive any benefits. Therefore, extending Dames and Moore to this EO would likely raise a legitimate takings claim. Anyway, it talks about them being able to privatize. But here's the conclusion. In this essay, I have considered 1. Whether Executive Order 13303 attempts to bar lawsuits against private companies. 2. Whether the President had authority to issue the order. And 3. Whether the order merely changed the substantive law or resulted in an impermissible withdrawal or modification of federal jurisdiction. My initial conclusions are that this executive order attempts to bar lawsuits against private companies and that the order lacks authority. President Bush has arguably crossed the line drawn in Dames and Moore and withdrawn federal jurisdiction. However, as I indicated at the outset, the purpose of this essay has been to raise questions for further discussion. There will be other questions that need to be answered, such as whether Congress could delegate its power to modify jurisdiction to the executive, or under what circumstances may the executive settle claims between private parties. This essay will only start the discussion about the remaining scope and authority of this order. Whatever direction the discussion takes, we should be deeply concerned about the scope of this order and its implications. In Dames and Moore, the court upheld the Iranian suspension order absent explicit congressional authorization because of the President's long recognized power to settle claims with foreign governments. Here, accepting the President's conduct without question will have a cost even if there are never any injuries, oil spills, or suits for conversion. Congressional acceptance leaves a gloss on executive power. Granting the President power to change the law without providing an alternative forum creates a troubling precedent, and silently granting such power to the President with respect to claims against private individuals is dangerous. Perhaps the executive will argue that the situation in Iraq is so unique that the court should find that the Dames and Moore paradigm should extend, or that the foreign affairs concerns justify the immunity given to private companies. Maybe the situation in Iraq is unique, but even so, the analytical framework for dealing with executive orders mandates that we critically examine this executive order. Dames and Moore, in the cases delineating presidential powers, tell us emphatically that past practice matters. Congressional acquiescence in these types of executive orders leads to the conclusion that the president is acting within his authority. Congressional silence equals acceptance. The words of Justice Frankfurter in Youngstown now sound a chilling warning. A systematic, unbroken executive practice, long pursued to the knowledge of the Congress and never before questioned, may be treated as the gloss on executive power vested in the President by Section 1 of Article 2. We cannot afford to gloss over the questions raised by this executive order. So, what you have with 303, they control Iraq's assets, basically is what it amounts to. That not only do they control the assets, they have protected all the private oil companies from injury. This is insane, and it should have been challenged a long time ago. And they keep continuing this as how did Biden put it? Orderly reconstruction. America can't get its own act together, yet we're going to tell another country we're going to steal their oil money and give them a pittance as we deem fit, and tell them how to run their country and how to rebuild their country. It just makes absolutely no sense to me. I can't wait for Iraq to grow some and to get this thrown out. It's time to tell America you don't have any right after 20 years, it's been nearly 21 now, that it's time to let us go and let us do what we do. There is no security risk, only a lack of control by the U.S. The U.S. is a bully, but they do it under the guise of protection and all that. It's, yeah, we're no better than most other countries when it comes to standing up for what's right. The U.S. stands up for what's right when it benefits the U.S. And in a lot of cases, that's a good thing. But in this case, it's time to let Iraq flap its wings and leave the nest that the U.S. has built around it. So come on, Iraq. Let's start fighting. Let's make sure they don't renew. And whoever becomes president January 1 of 2025, look at what this executive order is doing. Look how it's protecting. We've got a choice between, well, the idiot that's in there now and someone who says they can't be bought. Well, if you can't be bought, then don't allow this executive order to remain. You had 4 years to remove it and you didn't. And you're probably not listening to the right people. But it's time 13303 disappear.